Good morning and welcome to another episode of Gough Square Live. I'm Crowe KC and today I, along with Daniel Brayley, will be talking about the brand new offence of failure to prevent fraud, introduced under Section 199 of the Economic Crime and Corporate Transparency Act 2023 and which came into force yesterday. The offence seeks to make large organisations criminally liable if persons associated with them commit certain specified offences of fraud with the intention of benefiting the organisation or any person to whom the organisation or its subsidiaries provide services. Now, this is potentially a wide-reaching offence with extraterritorial effect, meaning it can be committed by organisations based outside the UK. Unlimited fines upon conviction and the single defence, if the underlying fraud is established, of having reasonable procedures in place to prevent the relevant fraud. It is likely and certainly hoped by the government that the new offence will fundamentally change the investigation of fraud within large organisations, place an onus on such organisations to proactively take steps to stop it and, importantly, increase the prospects of fraud being successfully prosecuted. But is that truly likely to happen? Well, in trying to answer that question, we together will have a brief look at, firstly, why the offence has come about, secondly, the key elements of the offence, thirdly, the statutory defence, fourthly, the investigation and enforcement of the offence, and finally, we'll conclude with a few thoughts about unanswered questions and the way ahead. So dealing with point one then, why has the offence been introduced? The simple answer is fraud is big business. The Office for National Statistics suggested in April of this year that there were 4.1 million incidents of fraud in England and Wales in the last year. The problem is such that despite the government launching a comprehensive fraud strategy in 2023, it has promised a new strategy for later this year. A report from as far back as 2020 by Sir Craig Mackey into failed fraud prosecutions highlighted the need for a new future for fraud investigation due to, amongst other things, a lack of resources and the feeling that fraudsters can operate with impunity. Also in 2020, the then director of the Serious Fraud Office described the UK's fraud laws as, quote, antiquated, end quote, and suggested that the SFO was hamstrung in its attempts to establish corporate liability for fraud. The law, she said, plain and simply needed to change. But why? Well, prior to the new offence coming into force, a corporate entity would only be criminally liable for a fraud offence if it was committed by the directing mind and will of that entity. This is known as the identification principle and has been a tricky thing to establish, as proved in several high-profile corporate fraud cases over recent years. In essence, prosecutors have struggled to prove that dishonest conduct was attributable to the company being prosecuted. The SFO versus Barclays, a prosecution for December 2018, is a good example. In this case, in which secret payments were alleged to have been paid by individuals within the bank in the context of raising capital for the bank, the dishonest actions on the evidence could not be said to extend to the bank's board of directors. If the dishonest acts were not done with the knowledge of that board, which was the directing mind and will of the bank, then the bank was not and could not be liable. Now, such liability may be established in small organisations, perhaps where there is a single director who runs the company and makes all the decisions. However, in large organisations where responsibility and decision-making are often spread to several individuals or even committees or boards, establishing that the conduct was done by its directing mind and will was, in the view of many, close to impossible to prove. So, it is in the context of fraud being widespread the investigation of it being under-resourced, and a suggestion that the law was antiquated and preventing the proper investigation and prosecution of large organisations for corporate fraud, that this offence has been introduced. So, Daniel, why don't you tell us about the elements of the offence?
Thank you, Cameron. I'm now going to look at the key elements of the offence. The offence of failure to prevent a fraud is found in section 199 of the Economic Crime and Corporate Transparency Act 2023, the Act. It is an either way strict liability offence and will generally be made out subject to the prevention procedures defence, which I'll consider later, where a person associated with a relevant body in a financial year commits a fraud offence intending to benefit directly or indirectly the relevant body or any person to whom or to whose subsidiary undertaking the associate provides services on behalf of the relevant body. Quite a mouthful there. I should point out that a fraud will not generally be committed under subsection 1b if the body itself was or was intended to be a victim of the fraud offence. Well, who needs to be concerned by this new offence? As Cameron mentioned earlier, the new offence specifically targets companies, large organisations specifically. These will be companies that meet two of the following three criteria. First, the company has a turnover of more than £36 million. Second, a balance sheet total of more than £18 million. Or thirdly, the company would have to have more than 250 employees. So if two of those three are made out, the company will be a relevant body for the purposes of this offence. The Act, of course, may also apply to parent undertakings in certain circumstances, but I don't have time to deal with that at length today. Now, there's two key points to note at the start when looking at this offence. First is that prosecuting authorities will still, of course, need to prove that an underlying fraud offence has been committed. No easy task. And second, that that offence has been undertaken by a person associated with the relevant company. Now, dealing with the first point, proof of an underlying fraud. The failure to prevent offence obviously requires, as I've just said, the commission or attempted commission of an underlying fraud offence by an associated person. Now, I'm going to refer to the underlying offence as base offences for these purposes, and they are listed in Schedule 13 of the Act and include both common law and statutory frauds, as well as aiding, abetting, counselling and procuring the commission of the offence. The listed offences in the schedule include, for example, fraudulent trading contrary to section 993 of the Companies Act 2006, something that trading standards departments up and down the country will be greatly familiar with, as indeed Cameron and I are. Cheating the public revenue, which of course remains a common law offence. False accounting and false statements, either by a company director, contrary to the Theft Act, or offences under the Fraud Act 2006, for example, Section 1 fraud, or participating in a fraudulent business carried on by a sole trader, Section 9, or obtaining services dishonestly, contrary to Section 11. Now, it is worth noting at this point, as Cameron has already mentioned in his introduction, that this offence has extraterritorial application. Now, what does this mean? This means that the company does not need to be incorporated in the UK for the offence to apply. It will be sufficient for these purposes to establish that any act that needs to be proved as part of the fraud occurred in the UK, or that the intended loss or gain was due to take place in the UK. Now, if I pause here for a minute to reflect on what I've just told you, it is quite clear that the range of base fraud offences is very broad, but prosecutors obviously will need to be able to establish that such base offences have been committed by an associated person before the failure to prevent offence can be considered. So what is an associated person? Well, again, we've got a very broad definition here. It will include a person who performs services for or on behalf of a relevant organisation within the scope of the irrelevant offence. Now, these will include, for example, directors, employees, agents, subsidiaries, intermediaries, and in certain circumstances, contractors or consultants. Now, we would also note that this test is purposive rather than formal, therefore it turns on the nature of the relationship, and in practice, the court will need to consider all of the relevant circumstances when considering whether an individual is acting in the relevant capacity. Now, the broad scope of this definition must be borne in mind when companies are considering the scope and the extent of these relevant procedures for the purposes of the statutory defence. For example, companies will need to consider who needs to attend any training, what should be covered by the training, who falls within the scope of certain policies. And this is an appropriate point then for me to move on to the third key point that I wish to consider in this talk, and that is the statutory defence of prevention procedures. The third key point to note when looking at the statute is that in common with other failure to prevent statutory type offences, such as the failure to prevent bribery, tax evasion, and indeed offences in other areas that we cover in chambers, such as health and safety at work, the Act includes a due diligence type defence. Now, it's referred to in this context as prevention procedures. Now, we strongly anticipate that this is an area where both companies and prosecuting authorities will need to focus attentions, and that companies and prosecuting authorities are likely to benefit from advice and input from expert legal counsel, experienced in considering and advising on due diligence type defences in those other contexts. Now, what section of the Act am I talking about? Well, we're looking at sections 199(4) and 5 of the Act, and it provides that a defence may be available to companies where at the time of the base fraud offence is committed, the company had in place such prevention procedures as it was reasonable in all the circumstances to expect the body to have in place, or where it was not reasonable in all the circumstances to expect the body to have any prevention procedures in place at all. What is a prevention procedure? Well, they are procedures that are specifically designed to prevent persons associated with the body from committing fraud offences. A broad definition, you might think. A helpful starting point then, when assessing these procedures, will be the government's own guidance, which was published on the 6th of November 2024, pursuant to section 204 of the Act. This guidance, taking the lead from guidance in the context of bribery and tax evasion, sets out 6 principles that are relevant when considering prevention procedures. Now, these will include top-level commitment, risk assessment, proportionate risk-based prevention procedures, due diligence, communication, including training, monitoring, and review. Now, it is plain from that list that senior management will be expected to take an active role in assessing risk, and they will need to demonstrate ongoing commitment to training and resourcing. Budgets will need to be allocated to fulfilling these objectives. Now, these items in this list won't come as a surprise to companies and indeed to their lawyers and counsel who will be experienced in advising in this area. It is clear to us that any proportionate, and proportionality will be key here, risk-based prevention procedures will need to be specifically tailored. Businesses will be greatly assisted in this process by counsel who are experienced at looking at such processes in similar contexts, including, for example, bribery, or, as I've already mentioned, health and safety, where equivalent due diligence defences lie. Senior management will also be expected to lead by example and to ensure clear governance in the fraud protection framework. They will need to work towards an open culture where people feel that they can report potential offences without reprisal. It is also clear to us that the review process will need to be ongoing and importantly documented. In sum, companies will need to continue their review processes to ensure that they are putting their best foot forward, and at all times, an expert legal counsel is ideally positioned to assist in that regard. The joint SFO and corporate prosecution guidance notes, and we agree that the principles above are likely to assist when prosecuting authorities consider whether a company has sufficient prevention procedures in place. More specifically, The above structure will likely assist authorities in identifying lines of inquiry, in examining areas of weakness or omissions in the prevention procedures, structuring interviews, and importantly, in informing prosecutors' assessment of the strength or weakness of any claimed offence during evidential reviews and charging decisions. It is regrettably beyond the scope of this talk to work through the guidance in any greater detail than that, I'm afraid, although we, of course, both Cameron and I, will be happy to respond to any questions that you may have. Do feel free to email into Chambers after the talk.
Yeah, thanks, Daniel. Amongst a couple of shameless plugs there are reference to a lot of issues that we have dealt with a lot in other areas. Advising on risk assessments and prevention procedures is not, even in the context of a new offence, they are not new areas. They exist in other areas of law, they have been dealt with, and they're going to be transferable to this new offence. However, let's turn now and look at the investigation and enforcement of this new offence. A key question that many will be asking is who can or will investigate and or prosecute. Firstly, there is nothing in the Act limiting who can either investigate or prosecute a new offence. Accordingly, it appears legally possible, at least, for any regulator whose activities deal with fraud to both investigate and prosecute the offence, subject, of course, to its own limitations. By way of example only, local authorities, who of course prosecute a range of offences, including fraud, health and safety, and consumer offences in particular, are creatures of statute that regularly deal, as I said, with fraud offences, and they may find themselves considering the offence and a possible prosecution. But any such prosecution would have to be in accordance with a local authority's power to prosecute. So you'd be looking at section 222 of the Local Government Act, or perhaps paragraph 46 of Schedule 5 of the Consumer Rights Act. The point is, whilst the offence may not have restrictions on who can investigate or prosecute, the nature and legal basis of any given regulator might restrict whether they can do so. Published guidance would suggest that the Serious Fraud Office and the Crown Prosecution Service are gearing up to tackle the new offence and will be the most likely to investigate and prosecute. In addition, the nature of the offence and the fact that investigations will necessarily be complex and lengthy lends itself to larger enforcers and regulators such as the SFO being the ones to pursue the offence. That said, the government guidance does refer to other regulators prosecuting, including the FCA and the pensions regulator. So it is still to be seen exactly how this will play out. So, in concluding this brief whistle-stop tour, will the new offence bring about change, and possibly significant change at that? Well, in our view, it certainly has the potential to do so, but many issues remain unanswered. In particular, whether adequate resources will be provided to allow for the proper investigation and, if appropriate, prosecution of the offence. That lack of resource has been highlighted over the years repeatedly as a reason for fraud investigations and prosecutions either not being undertaken at all or failing if they are brought. Widespread change has been heralded before with the introduction of new offences similar to this new offence. For instance, the corporate offence of failing to prevent the facilitation of tax evasion comes to mind under the Criminal Finances Act 2017. It was heralded as being a game changer, yet the first prosecution has only just been reported on, with a trial due in August 2027. That's 8 years after it coming into force, and despite over 100 investigations, we're only at our first prosecution now. Any investigation and prosecution into this new offence will inevitably be complex, resource intensive, and come with high stakes. And there is, in our view, a danger of the offence becoming another, quote, paper tiger, unquote, in the absence of proper resourcing and, importantly, prosecutorial will and determination. However, Large organisations should be ensuring they have put preventative procedures in place because the risk to their businesses, financial and reputational, are substantial. And with that whistle-stop tour, we'll draw the curtains on this talk. We hope you found it useful, and we are, of course, as Daniel's already said, happy for anyone to get in touch with any questions that they may have. So finally, as is custom, it's left to me to simply advertise the next Gough Square Live talk. That will be on the 7th of October, and I'm afraid you're going to be stuck with me again, but I will be on that occasion with Jack Brady, who doesn't have curtains, which probably everyone will be glad to see. And we will be talking about the SRA's recent finding of poor practices in law firms conducting high-volume consumer claims. This, of course, is of particular importance given the prevalence of such litigation at the moment. There's Motor Finance Commission, PPI, vehicle emissions, and the mis-selling of solar panels, to name a few. We will be looking at some of the common issues, the duties on law firms, both professional and legal, and what the consequences may be if they are breached to consumers, the law firms themselves, and importantly, to any of the litigation that they are involved in. So until the 7th of October, goodbye.